What's up, guys? Welcome to this is not our first back-to-back live stream, I don't think, but we just had one last night, and here we are. It is Thursday, January 4th, 2024. But for me, today is Christmas because we just got the answer from the Michigan Republican Party Trust to Kristina Karamo's lawsuit against them. I heard there was also an answer from Comerica Bank that came out today, but we don't have it yet because apparently it is so long that it's going to take them several more days just to type it all up or to make it available for the public. But we do have that, and we're going to go through it tonight, folks. So joining me tonight, we have Warren Carpenter, one of the major troublemakers in the state party. He might say, although is in my view personally, he's the one holding them accountable. But and Matt Wilk, the until recently chair of the Wayne Sixth and an attorney and frequent guest of the show to talk about what we're going to be reading through tonight. So welcome, gentlemen. Good to see you.
Good to see you.
Hey, thanks for having
me. You guys had a happy New Year?
Oh yeah, it was wonderful. It was wonderful. We're all looking forward to the changes that 2024 will bring, and they might come very quickly. So
I hope so. And I think this might kickstart the process because ultimately the people who decide Kristina Karamo's fate are the state committee members, and they're the ones on the hook for all this stuff, which we'll be talking about in a moment. By the way, hello to Heather Dow on X. We now can actually view the comments on X in real time. So if you like free speech, Rumble is a great platform. So is X. You are welcome to join us on there. But we are also streaming on Rumble. I do periodically check the comments there as well. And I see you guys, Iceman99 Turbo and Patricia on YouTube as well. So feel free, folks, if you have questions as we go through this stuff, to ask them, and we will try to answer them in a timely manner as we are able. But we do have some things to get through. And in fact, this just came through my email moments ago. This is an invitation that I believe originally was only offered to county chairs. It has now been extended to Republican state committee members, county chairs, and precinct delegates. If you would like to join Kristina Karamo, or maybe not Kristina, it says General Counsel Dan Hartman is doing a call tomorrow.
Yeah, if you'd Dan Hartman is going to do a separate. Yep, he's going to do a separate town hall. Yep.
Interesting. Well, this is addressed to the state committee members, county chairs, and precinct delegates tomorrow at 8 p.m. So if you'd like to ask them questions in an environment that they are in complete control over, then this is the way to do it. So you can ask a question for 30 seconds and they'll answer for 15 minutes or whatever it takes. We'll see. Matt, you were on that call the other day with Kristina, where she pretty much had the complete monopoly. I was given, I think, 20 seconds to ask one question, and Kristina and Jim Kopitz got to BS for like 2.5 hours. It was outrageous. But here we are. This is the information. It is on the screen. And yeah, so there it is. I'm not going to leave it up for too long, but if you want to tune in tomorrow, just pause the video, or our video will be on YouTube, immediately available, and it shows up on Rumble as well. So you can always just pause the video or rewind. Daniel says, I did not get this notification. If you are not a precinct delegate, Daniel, I don't know. If you are a precinct delegate, I don't have to tell you, man. I mean, I can tell you because I run a county party. Sometimes we have members who do not get our emails for any number of reasons. Sometimes because we don't have their email address. Sometimes because their mailbox is full. Sometimes because they unsubscribed. They didn't realize they unsubscribed. I've seen that happen. So I'm not going to impute any malintent to Kristina on any of these things. But there's the information on the screen, guys. So you have it now. So there you go. Anyway. Before we get to the really juicy stuff, and that, of course, is this document, which is the answer from the Michigan Republican Party Trust to Kristina's lawsuit. Another thing came out, or it came to my inbox today. I don't know if you gentlemen have heard of this before today. I know. Let me make the screen bigger, so that might look better. But I didn't see this until today. I was not aware of this until today. But this document came out exactly 1 week ago, and I think it's kind of relevant for today's discussion. This is an order for contempt of court against Darren Wisely et al., which means and others. And it is an order of contempt against Darren Wisely and others Those others being, let's just skip to the
I
bottom
would
here.
love to discuss this.
We're going to go through it. This is a shorter document than the other one. This is 7 pages. The et al appears to be, actually, come to think of it, the name on that, what was it? Wisely is not named in this contempt order, but Mr. Mosby, Mr. Smith, Mr. Gritzmaker, Respondent Karamo, and the Michigan Republican State Committee have been assessed a fine of $500. Oh, here, I'm sorry. Let me switch to this tab. Mr. Mosby, Mr. Smith, Mr. Gritzmaker, Respondent Karamo, and Respondent Michigan Republican State Committee have each been assessed fines of $500. And they have also been ordered to pay the defendants, the plaintiffs' legal expenses, attorney fees related to the investigation and prosecution of the contempt. The liability of defendants and respondents for the payment of attorney fees shall be joint and several. Well, let's talk about what that means for a second here.
So
that means
I got a piece of inside information for you real quick, Adam.
Yeah.
I tracked down what the estimated attorney fees on this are, because I spoke with the attorneys. It's $50,000.
Yep, I've heard that too. So when they say the liability of defendants for these attorney fees, these $50,000 plus another $2,500 being joint and several, means that if any of them don't pay for whatever reason, the others are all still liable. I mean, they might be able to sue one another to get a judgment against one another, but if Mosby, Smith, Gritzmaker, and Karamo don't pay, then the state committee is liable for all of that.
That is
so
correct.
let's go through what this is here.
Correct.
This is not a big document. You don't have to read every word of it, but let's set the table here for folks. Plaintiffs filed a complaint. Now, the plaintiffs are this Hillsdale County Republican Executive Committee, which I interpret to be the Hillsdale County Republican Party.
Well, so I read through it and I've had multiple conversations. I can summarize it pretty easily for you. So
Yes.
basically, there was a dispute in Hillsdale County over which group of people controlled the executive committee, A or B, right? And the details, frankly, are kind of irrelevant. So
I was going to say that too, man. I'm aware of all this stuff too, and you're right. The details are irrelevant, but go ahead.
They're irrelevant. And the court in this particular case said that this group, the Hillsdale County Republican Executive Committee, were the lawful ones in charge of it. That's what a court ruled. A judge in Hillsdale County, a circuit court judge. Okay. The state, not only there was the allegations in the document or in the order, they're not allegations anymore, they're part of the order, were that some of these members of the committee tried to form their own group or otherwise held themselves out as the members, the actual members of the Hillsdale County Republican Executive Committee or Republican Party. The terms are used interchangeably in the document. But importantly, for what the conversation that we're having, because that's kind of a small internecine dispute, is the state, with the people that they have, ignored the court order.
Yeah.
So the Kristina and the state committee are fine, particularly because on the state website, they showed the content when they said, who are the county chairs?
Here, this is the state party's website pulled up just moments ago. This is still there.
Today, still there.
And if you go to the link here, the link is to hillsdalecountygop.com. That is this webpage, which still very clearly represents itself as the Hillsdale Republican Party.
Right.
So to this day,
to this day.
Yeah.
Now, whether you agree with this judge or not, one of the things I constantly have to tell people as attorneys, as an attorney, is look, what you read on TV or see on TV rather is not real. Okay. This is not Judge Judy. This is not any of these shows you watch. You don't get to avoid what the judge orders you to do and say, I'm not paying, I'm not listening, I'm not going to follow. Now, individuals, it could kind of be maybe excused a little bit. Maybe you didn't read it. Maybe you didn't understand it. Maybe there wasn't clear. I'm not sure. Neither here nor there. When you're Kristina Karamo and you have access to ostensibly what I were told, you and Adam, you and I were told last week are brilliant legal minds. None of these brilliant legal minds said you best follow the judge's order. And the judge, having issued an order that the state GOP ignored and that Kristina specifically personally ignored. Judge found you owe a fine pursuant to that particular court provision, and the money that it costs this group to pursue that in legal fees, you're paying that too.
Can I just interject real quick and just let the audience know that what you're referring to is all she had to do was change a name on a website from a judgment order that was entered in April of 23, people.
Right. This is all she had to do was change this to comply with the court order. And then she and the state committee would not have been held in contempt of court had they simply followed the court's order, even if they disagreed with it. And and by the way, let's go through this a little bit because the details are kind of interesting. So they filed this complaint. The court found it did have jurisdiction, and that's interesting because the defendants challenged us on subject matter jurisdiction to resolve a political question. And we've heard about other cases where the court's found differently. I don't know the facts of this case, folks. You don't either. And even if the judge's decision was wrong or inconsistent with this other court, doesn't matter. This was the finding of the Hillsdale County Court. And the remedy they have is to appeal it. That's the only remedy they have for disobeying the judge's order. But they didn't do that. Emma Birch says, holy S, it only took changing a name on a website, and now it's going to cost people $50,000. This is so reckless. Yes.
No, it's far more than $50,000, because if you understand what the $500 to state committee means, it's not a $500 fine for just the state committee. It's separate and then joined. So each one of 1 through 5 are separate fines for $500 per state committee member. And then it's $50,000 for the legal costs. It's over $100,000.
It's not 500 per member. It's 500.
No,
It's not? Okay, I just want to make sure.
It's a total of about, but it could be as much as $52,500. That's a lot. That's a lot. That's a lot of money.
Okay, correct.
And because you thought you didn't have to follow the court order. Now, particularly, you might ask yourself, why? Why did she do this? Why did she ignore the court order? Well, which are these people on her side or on the other side, which she does routinely when she doesn't, she views this as, I'm sure she probably called the judge a globalist or a member of the WEF or whatever, what have you.
Yeah.
Instead of just listening to what the judge told her to do, which was change your website.
Yeah. So this is interesting. Standard of proof, this section. Case law has not clearly defined the standard of proof that applies to civil contempt proceedings. Many cases have applied the clear and unequivocal standard. Other cases have applied the preponderance of the evidence standard. The purpose of this opinion and order, the court will apply the clear and unequivocal standard, meaning, this is to make it even more appeal proof. It's clear and unequivocal that she just disobeyed this court's order.
Yeah, failure to act, just like not paying her parking tickets.
Yep.
Yeah, and furthermore, just about when you ask the question of appeal, this is an interlocutory order. It's probably not appealable.
Yeah, it's not.
The order that was appealable was the one that was in April. Query, if you felt so strongly about to appeal it in April, it can't be that you didn't know, because remember, you had these brilliant legal minds that were working for you. Yeah. And I say that in all facetiousness.
Yeah. Here's another funny part here. This event, they have this event called the Comic Zoo event, whatever the heck that is. So their first annual Comic Zoo was an advertisement using the Hillsdale County Republican Party logo. And then the Comic Zoo was also advertised on the Hillsdale County Republican Party Facebook page. That page names Mr. Smith as the owner and includes the words, "We are the official and sanctioned Hillsdale County Republican Party page." That seems almost like they're deliberately trying to make clear, no, never mind what this judge says. We're the official Hillsdale County GOP. And this is that page today. America, it's changed a little bit. Now it's the America First Hillsdale Republicans, parentheses, MI GOP certified page. That's their, which is clearly they've changed something maybe to mitigate their liability, but that's not enough. I mean, this still clearly makes it look like they're the official Republican Party page. Hey, there's my good friend Shane right there. So they've acted in some way. I don't think this is going to do anything for them though, but that's on them. Except that, well, this goes on and on and on. Yep, there's the website. We already looked at that. contumacious acts of respondents, Michigan Republican State Committee, and Kristina Karamo. In addition to enjoining the actions of defendants, the court's order enjoins all other persons acting in concert or participation with defendants from engaging in and actions prohibited by, no typo there, prohibited to defendants. Plaintiffs, apostrophe, allege that respondents, Michigan Republican Party, and its chairperson, Kristina Karamo, have violated this order by holding defendants Mosby, Gritzmaker, and Smith out as officers of the Hillsdale County Republican Executive Committee. This court has previously ruled that it has jurisdiction to resolve this matter with respect to these non-party defendants. Mr. Littinger's unrebutted testimony was that on May 3rd, plaintiff's attorney sent a letter via email to Michigan Republican Party chairperson Kristina Karamo. Oh, well, there's a defect right there. She doesn't read her emails. Michigan Republican State Committee, and to Mr. Hartman as attorney for the Michigan Republican State Committee, that included a copy of the court's April 28th, 2023 order. The letter further advised the state party website names David Mosby as chair of the Hillsdale County Republican Executive Committee. Hyperlink, we looked at all this stuff. Testimony was unrebutted as none of the defendants called any witnesses or offered any evidence. Therefore, there is clear and convincing evidence establishing that Ms. Karamo, the Michigan Republican State Committee, violated the court's April 28th, 2023 order, and therefore 7 months later, they are subjected to paying back the attorney's fees that had the state party just changed their webpage, only these other 3 people would be liable for that. But now the state party's liable. And if those other 3 don't pay, they're fully liable.
Yeah, I mean, look, this is not a game. You can't say, I'm not going to listen to what the judge says. And you particularly can't do that in such a way that you literally did not respond. You could have responded in a million ways. Sorry, we'll get to it as soon as we can, Your Honor. Our bad, we didn't get a copy. What you could have responded in a million ways.
My dog ate my court order.
Whatever it is, exactly. And judges are going to be pretty lenient, but not responding to them and not ignoring them. And unfortunately, this is a pattern. And what some people have said, attorneys that are talking about this issue have said, look, this kind of stuff, you may see this on television, let people act this way, but in reality, this stuff can bite you in the butt really hard. And this is like the gentle bite, and then the other one we'll talk about later is
we're coming right to it. But just to transition to this answer that we got from the Michigan Republican Party Trust today, I think about my state committee members from my county. One of them is our county party treasurer, Bill Gordon. The other is a township clerk named Michelle McQueer. They have absolutely nothing to do with any of this other than being members of the Michigan Republican State Committee. They had no ability to change what was on that website. And they are now personally being held financially liable by a court for the gross misconduct of Kristina Karamo. And this is not something the globalist made her do. This is something she chose to do, to defy a court's order. Period, paragraph, end of story.
Yeah, and the other thing I want to raise is, there was no vote on this. Nobody said, you know what, we really want to get enjoined in this battle in Hillsdale. And it's very reminiscent of the Kalamazoo fight that still kind of simmers underneath the surface today, right? This is the proof in the pudding that these people think that they have control over what counties can dictate to delegates. Yeah.
By the way, on Rumble, Hitman48 says Democratic infiltration operation. Yeah, I've come around to that view, and I know, Warren, that's been your view for some time. But
Thank you, sir.
We had this long conversation with Kristina. Well, not exactly a conversation, but the other night. But to hear her just totally misstate facts, lie about people, accuse people of things, it was absolutely clear. Like this is a complete willful series of acts of misconduct.
Okay, so if you want to do a live one to just make Warren's point, Adam, will you please go back to the MIGOP website and look at the county chairs and go to the letter K.
All right, here we go. About county chairs. Go to the letter K. So
the
like
letter
Kent
K.
County.
What's missing there? That's interesting. Between Jackson, Kent, is there a third county?
Coolum.
Yeah, it's like in a bunch of limericks, I think. That's so weird.
Between Jackson and Kalkaska?
Yeah, it's Kalama something. It's actually a county in Michigan.
Yeah, that's
Oh,
right.
yeah.
That's a song sung by the band Primus, for example. It's a famous city, Kalamazoo. It's such a funny name.
Yeah, it's a famous city, and it's a big county. It's one of Michigan's biggest counties. It's bigger than Kalkaska or Ionia or Asco or Iron or Isabella. It's got a big
Yeah.
city in it, also called Kalamazoo, shockingly. And magically, the county chair, Kelly Sackett, her name's not on here.
Wonder why that would
It's-
be.
No,
It's not like
really
a court's
weird.
ordered that Kelly Sackett is the chair of Kalamazoo County, is it?
They in fact
No.
did.
There
No
we go.
kidding.
And this is pretty typical of now, did she ask anyone in the state committee, hey, I'd like to remove this major county from our website because I disagree with what Kelly did when she ran her county? Nope. Does anyone know this? Nope. And then you look at it, you're like, why do you, here you are putting yourself at risk of that county going to that judge and saying, hey, this is what you ruled. We're not even the state committee, specifically the chair, is ignoring what you said. We'd like an order to have us included. Sure.
Amazing.
Yeah, they go back to court on January 22nd.
Wow. All right. Well, let's get to it, folks. We got to get to our main event here because we're already 20 minutes in, and this is the show. This is a 171-page document. However, most of those are exhibits we can just skip right through. It's about 18 pages. State of Michigan, Ingham County Circuit Court, Michigan Republican Party by Kristina Karamo in her official capacity as chairwoman of the Michigan State Central Committee, plaintiff. I like how that was read out there. Versus Michigan Republican Party Trust and Comerica Bank and Michigan Banking Corporation defendants. And you've got the rest of the caption here. Defendant Michigan Republican Party Trust's motion for summary disposition and for sanctions. By the way, Matt, you're an attorney. I've seen a number of lawsuits and things. Aren't sanctions usually like asked for kind of a ways into the process, not usually like right off the bat in the answer?
Normally, well, let me correct you, Adam. This is not an answer. An answer is where a defendant responds to the specific allegations in the case. In
Yes,
this
that's right.
particular case, it hasn't reached that level. What the defendants, Michigan Republican Party Trust and Comerica, I think Comerica Bank will say the same thing.
Correct.
Is even if everything you say is true, you still have no case. So we don't even need to give you an answer. We're just citing all this stuff right back to you. And oh, by the way, because the Michigan Republican Party has been a body for longer than since Kristina started, all the things that occurred under the Michigan Republican Party previously are known by definition to the plaintiff. Yeah. All those things in there, it's not even reached the level of an answer. So they say basically two things. Your Honor, even if everything they say is true, this should be thrown out. And Your Honor, because this had no legs to stand on in the first place, we'd like you to sanction them right away. Yeah. That is exceedingly rare, but reading what they wrote, it's not that it's unjustified.
But when the lawsuit is so frivolous, like it's time to go for the jugular, and the attorneys that they hired are savages, and
they're setting the tone too. Like I've seen cases where people didn't get the damages they wanted because they didn't respond hard enough, and they're making it clear. There is no actual controversy or genuine issue of material fact that the real property, commonly known as 518 and 520 Seymour Street, Lansing, Michigan, is owned by Seymour Street LLC. That the sole member of Seymour Street is the MRP Trust. Moreover, plaintiff's claim regarding the assumed name certificates is moot, and the assumed name filings terminated on December 31st, 2023. Accordingly, the MRP Trust is entitled to summary disposition of the entirety of plaintiff's complaint under, I'm not going to read off the court rules and compiled law citations or anything like that. The motion is supported by the accompanying brief, incorporated herein by reference. So that's basically the cover story. And then here's the brief in support of the motion for disposition and sanctions. The plaintiff has filed a lawsuit seeking a declaratory judgment that would be contrary to the plain terms of a real estate transaction that this very same plaintiff knew about, consented to, and participated in 18 years ago. That's to your point, Matt. Even though Kristina just came in, the Republican Party is, as it always was, a singular entity. To obtain the relief it seeks, the plaintiff has contrived a controversy where none exists. Indeed, the subject real estate is owned by Seymour Street LLC, a single-member limited liability company whose single member is the Michigan Republican Party Trust. That is where the story begins and ends. The Michigan Republican Party Trust is entitled to A, judgment in its favor as a matter of law, and B, because the plaintiff's complaint is frivolous, an award of sanctions in the form of attorneys' fees and costs incurred in defending this meritless case. Matt, do you want to explain why, as a matter of law, is so critical there?
Well, in order to file a lawsuit, you can't just fling stuff at a wall. Okay, you're not allowed to do that. You're not allowed. There's a standard called cases and controversies, right? And this was what we heard on the call that we had last week, and we weren't given enough an opportunity to respond because it was the most idiotic thing. No lawyer would ever do this, but the person talking wasn't actually a lawyer, so it explains why. You don't go to a judge and say, "Judge, I own this property." That's not a thing you go to a judge to say. If I'm suing you and I want to do something, that's a little different. Now, unfortunately, what these people did, because I presume they didn't get a professional litigator to look at it, is they in the complaint itself, it has all these facts.
Yeah.
It has the deed to Seymour Street. It has a title commitment that shows Seymour Street. And then it says, well, they don't own it. Right?
Correct.
And it has loan documents. And then it says, I don't owe you the money. And it's the most bizarre thing. No one's ever seen something like this. So what you say is, Your Honor, this isn't a factual question.
Right.
This is what they have said, plus things that are obviously true. Like something that's a recordable document is a matter of law, right?
Yeah.
Judicial notice it's called. If you lay those pieces together, irrefutable, then as a matter of law, there's no factual thing here. You throw it out. That's that means there's really nothing beyond nothing there.
Yeah. The issue is if there's a dispute of fact, the court has to hear evidence and decide the facts because the facts are in dispute. And a fact finder typically is a jury or a judge. But the facts are not what's in dispute here. Therefore, there's no need to have a trial. There's need to have a finding of fact. It's based on just what they gave you, Judge. This is all a bunch of garbage. So here's what they say. The MRP Trust is a sole member of Seymour Street LLC. And in turn, they are the owner of the property commonly known as 520 Seymour Street, Lansing, Michigan. The property was used for many years as the headquarters of the Michigan Republican Party. Plaintiff filed a complaint for declaratory and injunctive relief, requested the court declare, among other things, that MRP is the owner of the property. So now they give us a little bit of history. I wasn't quite clear about how exactly this all came to be, but they lay it out. There used to be an entity called the Michigan Republican State Party Headquarters Trust, or IRMST, which was formed in 1987. According to the IRMST Trust Agreement, the purpose of the trust was to hold real property for the use and benefit of the Republican State Committee. Under the terms of the IRMST Trust Agreement, the chairman and treasurer of the Michigan Republican Party would serve as trustees in addition to the 3 trustees of being appointed by the chairman. In this initial trust agreement, the grantor, the Michigan Republican State Committee, which is what the party was called back then, conveyed by an assignment of land contract its interest in the real property used at that time as the Michigan Republican headquarters located on 2121 Grand River Avenue in Lansing. So a different thing.
Right.
So around 2005, there was discussion between various donors, leadership of the Michigan Republican Party, and trustees of the MRPST regarding the purchase of a new headquarters. Eventually, the property...
Before you go on to that, though,
Yes.
Adam, people have to realize that in 2003, the state legislature actually passed a carve-out specifically so corporate money could be used to purchase 1 or 2 headquarters for either party only in Ingham County. This was a special carve-out of a legislative law that was passed in 2003. So that's how this corporate side of it came in. That's how they were able to use corporate money to purchase the building. It was a special thing that was passed by the legislature and signed into law by the governor for both parties in Ingham County to be able to buy 1 or 2 locations.
Special interest deal for Lansing. Imagine my shock. All right. So All right, so here we go. So Lansing Community College was identified as a good place for the new headquarters. August 2005, let's call it the old trust, authorized the borrowing of funds to purchase the new headquarters building, and authorized trustee and Republican Party counsel Eric Doster to sign all documents to purchase the new headquarters. On or about August 24, 2005, a limited liability company owned by a Michigan Republican Party donor, probably Ron Weiser, maybe Peter Secchia, paid the earnest money deposit for the purchase of the property, and the old trust signed a promissory note in favor of that limited liability company and gave a mortgage to secure repayment of the note when the Grand River property was sold. Given the requirements of various state and federal tax and campaign finance laws, it was determined that instead of the trust owning the real property serving as the headquarters, it would be preferable to create a limited liability company which would own the property and have the trust be the sole member of that company. Accordingly, Seymour Street LLC was created on September 19th, 2005, and the sole member of it was the old trust. The closing on the purchase of the property took place on January 9th, 2006. The grantee under the deed was Seymour Street LLC. The property transfer affidavit was signed by a trustee of the old trust as a member of Seymour Street LLC. Seymour Street LLC has remained the owner of the property since January 9th, 2006.
Okay, let me stop right there.
Go ahead.
Just for a little commercial real estate primer, because that's what I do for a living.
Yes.
Adam, if you own a building and you say, Matt, I'm giving you my building, does that effectuate a transfer of the building? It's not. Buildings, real estate has to be transferred through title. You must provide a deed in writing. It's called the statute of frauds. You're not allowed to transfer an interest in real estate greater than a year on an oral contract. So even if I put a sign out in front of your building and say this belongs to Matt Wilk, and even if you say to me, it's yours, it doesn't become yours.
But we shook hands.
Anybody who's had the first year of property law understands that concept.
Yeah. Okay. So the point being, well, let's
it's an LLC. The LLC owns it.
The LLC owns it. Gotcha. LLC is the owner, has been the owner this entire time.
Mm.
So now on December 5th, and by the way, I think the reason that sets the table for an important point is all the stuff in the original complaint by Kristina about the trust and this transfer. It's all blather. It doesn't matter because the owner of the property at all times was the Seymour Street Company. All right. Now on December 5th, 2008, the Michigan Republican Party Trust was created. It's called the new trust. The goal in the creation of a new trust, there it is, was twofold. First, the new trust was able to hold other assets in addition to the headquarters. And second, the new trust included former Republican Party chairs as trustees instead of the MRP chairman, treasurer, and trustees appointed by the chairman in order to protect the building and any other trust assets during periods of leadership transition to a greater degree than the old trust could. Gee, like they wouldn't want the state party chair to be able to stack the trustees of the trust and therefore be able to, sell the property somehow. Maybe that's what that was about. And so
and conceptually, look, for the benefit of the audience, the concept of the trust has been around on this planet for about 700 years. Okay. It started with kings and earls, and they would have a single son, and the son was a doofus, and they wanted to protect their assets and pass it on, maybe to hope that a grandchild would not be as bad as the dad. So they would put assets in a trust so that the trust could exert control, even from a third party, over the objection of the other person who would otherwise have control of it. So in the case of this trust, it's designed, oh, by the way, long before Kristina existed, right? It said the control is vested in a larger group and it can't be managed. You'll get to it a little later about what the terms and conditions are, but it can't be basically overridden by the current people running the state party, period.
Exactly.
Correct.
So on the same day, the old trust passed a unanimous resolution to transfer its sole membership interest and all interest in the headquarters building to the new trust. So dissolving the old one, adding the new one. George Hiller says, just checked, Hillsdale is totally gone from the MRP's webpage. You mean like since we showed it on the screen just now? Oh, man. Hi, Kristina.
Oh, wow.
Daniel.
That's great. Look at Adam, I want to say you're effectuating change that you don't even know it. You're actually watching and going, whoops, I guess we got to fix that.
Amazing. You know, the court's order fell on deaf ears, but little old me, my little live stream here, and suddenly people snap to action. All right. Anyway, on January 1st, 2009, the state party as tenant entered into a lease agreement with Seymour Street LLC as landlord for 520 Seymour Avenue for the MRP to use as a political office for annual base rent of $1. On October 17th, 2011.
Before you go past that,
yeah,
like I want people to understand, she's been going around telling people for an entire year that it was going to cost $12,000 a month to have that building. And you just said,
Yeah.
what? The entire lease is $1 a year. All she had to do was pay the taxes and utilities. And she could have even rented out other offices like they have in the past to who? House, the HRC, the Senate campaign committee, like all these other things.
501c4s, their friends.
Thank you. Yes.
Anybody.
She could have used it as a profit center. She refused it.
Yeah. She's got a text that KK isn't going to let it rip tonight. Oh, cool.
Oh my God.
I wish I had a TV to watch that with. And unfortunately, we're going to be probably still streaming when it happens because
she called me.
I have a feeling she will not do well on it, but I guess we shall see.
Well, I want to give you guys a little taste of that real quick. So they called me to ask if I would go on. When she called Lori Skibo to say that I would be on, she said Kristina wouldn't come on if I'm on. And then someone was there at the taping. They called me and said she called me a criminal and a liar. So we're gonna have to get some cease and desist going, baby.
Yeah. People are saying 10:30 p.m. Fox 2 Detroit. Okay. I don't know if I'm gonna have any way to find a live feed of that because I don't have TV. But if someone has it, please tape it for me, would you? If you have a VCR or something, or a TiVo, maybe. I don't know. Whatever people use these days. All right. Anyway, where were we? Oh, yes. On October 17th, 2011, Bobby Shostak, then chair of the Michigan Republican Party and also a trustee of the Michigan Republican Party Trust, signed and caused to be recorded an affidavit of interest affirming that Seymour Street LLC was the owner of the property and the sole member of Seymour Street LLC was the MRP Trust. So there you go. The trust it's been transferred from one trust to another, but the LLC, the owner of the building, remains the same. Amendments to the Michigan Republican Party Trust Agreement. On March 20th, 2014, the 2008 Trust Agreement was amended. The 2014 amendments included making clear that the term grantor in the Trust Agreement referred to the Michigan Republican Party, not to the Republican State Committee, because in the past, the State Committee was the name of the Michigan Republican Party. They changed their name. That's the clarification. That's all that was. And two, that the then current chair and treasurer of the Michigan Republican Party and the Michigan Republican Party State Committee are not beneficiaries of the trust. And three, to make clear the trustees are empowered to determine in their sole discretion as to how to use the trust property for the use and benefit of the state party, whether or not the then current chair and treasurer of the state party or the state committee necessarily agree with the determination of the trustees. And for allowing the Michigan Republican State Committee by 3/4 majority vote to override decisions of the trustees deemed in the best interest of the state party, and in further of the purpose of the trust instead of the 2/3 majority vote of the membership of the Michigan Republican Party. Sheila, we actually covered this at the top of the show. When it's all over, start from the beginning and you'll see the invitation and the link for that. So if you folks are just tuning in, you can do the same thing, rewind the stream, or it's on YouTube, and you can get the link for all that later. Anyway, on that same day, a new lease agreement was signed between Seymour Street LLC and the Michigan Republican Party, was executed for an annual base rent of $1 per year for the state party to use the property as a political office. Since March 2014, the trust has been amended twice, most recently on January 1st, 2023. In sum, there has never been any transfer of interest in Seymour Street LLC or the property from the Michigan Republican Party or the Michigan Republican State Committee because neither ever had any interest to transfer. At all times since the purchase of the property in 2006, the owner of the property has been Seymour Street LLC. The sole member has been, since 2008, the MRP Trust. Okay. Now we're going to get into a discussion about this other blather in the lawsuit about the use of the Republican Party name. Is there anything you guys wanted to add before we move on and start talking about this name stuff, the trademark stuff? Because I think this is all very confusing and it gets away from kind of the essence of the big stuff, but it's still important to go through.
Yeah, the one thing to point out, and this goes throughout the whole thing, that when the plaintiff is an entity, what the entity knew in the past, that knowledge is imputed upon them, whether the individuals who filed it knew it or not. So if you file something and you say, this never happened, and the other side shows that in a desk drawer, there was a piece of paper where previous officer of your corporation knew it happened, that's a real problem. You are required to do a certain level of due diligence before you file a suit. So it clearly wasn't done here because all these things were in the knowledge of the Michigan Republican Party in the past. And therefore, you don't move forward as an attorney or as a client to do anything until you investigate and get that information. Now, Kristina's mentioned we asked for paperwork and they wouldn't give it to us. This is all obvious stuff. When you got the title commitment and it said the property's in the name of Seymour Street LLC, the first thing you know is you don't own it. And it never was in your name. So why did you do this? Well, you were hoping that there's a piece of paper maybe somewhere in someone's file that says otherwise, but that's abuse of process, and you talk about it later in the end.
On Rumble, Hitman48 says, Kalamazoo was on the MIGOP site this morning at 10:41 a.m. Why not now? I don't know, but here, I'll refresh the page. Not there now. Anyway. Oh, by the way, did they change Hillsdale? Oh, look at that. Hillsdale just disappeared. Hillsdale's gone. How'd that happen?
Well, $52,500 is why.
Yeah. Anyway. All right, folks, let's get back to it. All right, now we get to this confusing stuff about the names and who has the right to use a name. So first, they're going to talk a little bit about this unrelated event, but that I guess gives some insight into the usage of the name. In 2011, an individual named Dean Hazel created a nonprofit company, named it the Republican Party, and subsequently solicited donor funds using the Michigan Republican Party trademarks, service marks, and symbols. The Republican Party and other plaintiffs sought and were ultimately granted an injunction against Mr. Hazel in March 2013. Cite the case, unpublished procurement opinion of the Court of Appeals issued yada yada date. As a result of Mr. Hazel's actions in the subsequent litigation, the state party and the party trust leadership determined that MRP's intellectual property should be protected through service marks and trade names. Accordingly, the General Counsel of the state party, at the direction of the state party leadership and the trustees of the MRP Trust, filed certificates with the Department of Licensing and Regulatory Affairs for Seymour Street LLC to transact business under the assumed name of Michigan Republican Party or other related names on September 26, 2013. This was done to protect the state party. See Exhibit 1. We'll look through the exhibits briefly. At that time, the interests of the MRP and MRP Trust were aligned. That's funny. John Dunlap says, who is her website administrator? Oh, we know who her website administrator is, don't we, John? John's our county chair, folks.
$90,000 worth of Joe Moss.
Yeah. Hope that website administrator doesn't have to do any depositions or nothing. I wouldn't want that to happen to him. He's a great guy. We in Washington County know him and we love him. I'm being a little facetious about that, folks.
Dripping off the microphone right now, everybody.
Huh?
Sarcasm is dripping off the microphone.
Yeah. All right. Anyway, where were we? Okay. Neither the MRP Trust nor Seymour Street LLC ever used the assumed names. Well, why would they? They're not like, they don't have a public face of a corporation, so why would they? Neither the MRP Trust nor Seymour Street LLC has taken any action to renew the assumed name filings, which have lapsed as of 4 days ago. Argument. Dismissal of plaintiff's declaratory judgment claims is not. Let me try this again. Dismissal of plaintiff's declaratory judgment claims is appropriate under Michigan Court Rule Yada because plaintiff's claims are not justiciable. The MRP, by the way, so they're done laying down the background facts now. I mean, there's some exhibits to refer to, but those are the most important. Those are the only important facts they need here. And now we get to the argument. The MRP Trust is entitled to summary disposition under court rules because plaintiff's claims are not justiciable. A motion for summary disposition is properly brought under Court Rule Yada, where the court lacks jurisdiction in the subject matter. Quote, in reviewing a motion under the court rule, it is proper to consider the pleadings and any affidavits or other documentary evidence submitted by the parties to determine if there is a genuine issue of material fact. And the quote from the citations is that the court must determine whether the pleadings demonstrate that the defendant was entitled to judgment as a matter of law, or whether the affidavits and other proofs show there was no genuine issue of material fact. Here, the court should grant summary disposition under the court rule because, one, there is no actual controversy regarding the ownership of the property, and two, plaintiff's claims regarding the ownership of the property are not ripe for adjudication. We'll look at that in a second. Well, they will look at that in a second. Similarly, with regard to plaintiff's claims regarding intellectual property, there's no actual controversy that the service mark Michigan Republicans belongs to the state party, and four, plaintiff's claims regarding the certificates of assumed name for the Michigan Republican Party Trust are moot. So now, A, this court lacks jurisdiction. That's the primary argument they're making. Declaratory judgments are governed by this court rule. The language of the court rule is permissive, not mandatory. Quote, a Michigan court of record may declare the rights and other legal relations of an interested party seeking a declaratory judgment. Emphasis added may. Accordingly, it rests with the sound discretion of the court whether to grant declaratory relief. However, if the existence of an actual controversy is a condition precedent to the invocation of declaratory relief. I think I said if where I shouldn't have. The existence of an actual controversy is a condition precedent to the invocation of declaratory relief. An actual controversy exists when a declaratory judgment is necessary to guide the plaintiff's future conduct in order to preserve the plaintiff's legal rights. In Van Buren case, the Michigan Court of Appeals considered whether summary disposition was properly granted to the defendants, who argued that the parties' disagreement over the meaning of a term in their contract did not present a justiciable issue, and therefore the court lacked jurisdiction to issue a declaratory judgment. In that case, the Court of Appeals reviewed the contractual provision at issue, which the plaintiff argued was ambiguous, and required declaratory judgments in order for the plaintiff to preserve its rights under contract. By the way, what did Jim Kopis say when he was explaining to the 6th District on this call a couple days ago why they filed this lawsuit? Because we just want the court to resolve this ambiguous question.
Yes.
The Court of Appeals found because the contract was unambiguous and the plaintiff's rights under the contract were clear, the plaintiff's claim that it needed declaratory relief in order to preserve its legal right was untenable. I'm sorry, Matt, you're going to say something?
No, I mean, you're going to get to it in the next page where basically he lays out the reasons why each of these, why these claims are not justiciable, and they're all, they're home runs, consecutive series of home runs. Okay. So you want to go to the next one? It's really clear.
Yeah. Well, let's just read on because we're already almost halfway through this whole answer.
Yeah.
I'm sorry, not answer. You were correct me when
motion for summary judgment.
Motion for summary judgment. Correct. Here, similarly, there is no actual controversy as to the plaintiff's assertions related to ownership of the property listed in subparagraphs, yada, yada, yada. Therefore, summary disposition is appropriate under the court rules. And now we have these three home runs. One, there is no actual controversy that the state party could not own real property, but more importantly, it simply does not own the property at issue in this case. First, plaintiff claims the court must declare that the state party and the Michigan Republican State Central Committee have the right to own real and personal property. Even if they were correct, that would not matter because neither the state party nor the State Central Committee, which is also the state party, own the property at issue in this case. The Michigan Land Title Standards is a series of selected statements of the law and of land titles as supported by applicable statutes and case law and is regarded as an authoritative reference on the law of land titles and other aspects of real property law as developed and interpreted in Michigan. Standard 10.4 provides that, quote, a conveyance to an unincorporated voluntary association, that's what the state party is, does not operate to vest title in the association, except in circumstances that do not apply here. Matt, if you know what those circumstances are and you want to elaborate, that's fine. If not, we can just
they're wholly irrelevant.
Okay, all right, I'll take your word for it. For this reason, the plaintiff could never have had title in the property. Oops.
Let's stop because there's a couple of parts to that. One that Warren's talked about a lot. There are reasons why the Michigan Republican Party cannot own real estate. So no matter what you say, it's an unincorporated association, and an unincorporated association may not own real estate. Now, you might say, hey, Matt, is there a case or something in recent history that describes this? There is not. Why is that? Because since about the 1930s, anyone with a half of a brain vested their title in something else. You had a comment from a guy named Jay Mashad about the unincorporated MRP. And we're going to talk about that a little later when we talk about the sanctions. But when you have an unincorporated association, it's much like an old-fashioned general partnership where every partner is liable for the acts of the partnership. Again, going back to the 1930s, nobody does it this way because anybody who has access to any sort of resources organizes as a corporation, an LLC, a limited partnership, a limited liability partnership, or some other corporate form for tax benefits and for liability protections. State party doesn't do that, never has, neither do the Democrats, right? It's not the Democratic State Committee, Inc. or LLC, because that's not how it's done. So to answer your question, we'll get to the liability. It's because there's no liability protection, but there still is in a partnership, just like a general partnership, there's the imputed knowledge of one member to another. So the entity still exists and it has a history and it knows things, right? And that knowledge is imputed and carries over without the liability protection. The reason why you don't see too much in the way of this anymore is because no one does it this way. They always set up their corporate form in such a way that they avoid that liability. It costs you approximately in the state of Michigan $25.
That's a lot of money for Kristina.
It's a lot.
All right. Michelle Marquette Smith says maybe if she hadn't steamrolled over all the Republicans who've been involved in the past, they would have told KK that the building didn't belong to her. The news told her the building didn't belong to her.
Nope. It's one better, Adam. When you go into the exhibits, you'll see.
All right.
Guess who knew she didn't own the building?
I love that email. I love that email.
Did she say that over and over and over again in emails that I've received?
Hold on, Adam.
Yeah. I know. I know.
If you want to jump forward, because it's
no. We'll get to it. And most people already know that.
You're holding it off for later. Okay.
Yeah, most people already know the payoff anyway. But here we go. So yeah, if you and me and Warren would like to get together and buy a building, there'd be a problem, right? Because we're not a corporation and we might have disputes or something. There'd be a problem with just three separate individuals owning a building. You wouldn't want to have
you can do that. It's called joint tenancy. There's a way to do that. But we can't form an unincorporated association and then get it in that's name. Because what the court would say is, no, that's not a lawful means of holding real estate. And when you went to your title agent and said, hey, I'd like to buy this in my unincorporated association, your title agent would say, no, you can't do that. Try again. Hold on. The lawyer walks out of the back room and goes, hey guys, no one's done this way since about 1883. There's literally millions of corporate forms you can choose. Choose any one of them. It's okay, but you just can't choose what you've done. So the answer to that is no, you cannot own property in that way.
On Rumble, UP Melanie says, John Dunlap, awesome analysis you did. I've shared a lot. Thank you. Thank you, Melanie. And that was a great analysis, John. For those who don't know, maybe we should put a link in the description or something, because John Dunlap sent around an analysis of, I believe it was this lawsuit, which is now all being proven by this very answer. So anyway, let's keep going here. Even if the Michigan Republican Party could have owned the property, which it cannot, it simply never did. Lansing Community College conveyed a fee simple interest to Seymour Street LLC in the property by warranty deed dated January 9th, 2006. We kind of went over this. While the statement is incorrect insofar as the property is actually owned by an LLC. Oh, so the plaintiff's complaint was wrong in saying it was owned by a trust. This is incorrect insofar as the property is actually owned by an LLC. Ms. Karamo nonetheless admitted that the property is not owned by the plaintiff. Oops. Further,
I love it.
The state party as tenant entered into leases for the property in 2009 and 2014 with Seymour Street LLC as landlord. This is likewise an admission that Seymour Street LLC owns the property. There would be no need to lease the property from Seymour Street LLC if MRP were the owner. MRP could not hold title to the property, but whether it could or not is not an actual controversy that exists between the parties of this lawsuit. The MRP does not own and has never owned the property.
And in their lawsuit, in the initial filing, they admit that.
Yeah.
They say, here's a title policy, and it shows the property is owned by Seymour Street LLC. Here's a deed, and it shows the title is of the property is owned by Seymour Street LLC. Nonetheless, we think we own it.
Yep.
That's not how it works.
Argument. That is their argument. 2, there is no actual controversy that the Michigan Republican Party Trust is the sole member of Seymour Street LLC, or that Seymour Street LLC is the owner of the property. Plaintiff, meaning Kristina and her lawyer, asks the court, because it does not mean the state committee, because they didn't sign off on this lawsuit, but that's a separate question. We'll get to that later, folks. Plaintiff asks the court to declare that the state party is the sole member of Seymour Street LLC and the owner of the property. These assertions are clearly negated by affidavits and other proofs. Under the plain language of Seymour Street LLC's operating agreement, the sole member of Seymour Street LLC was originally the old trust, which then assigned its membership to the newer trust. And there is no question that the owner of the property is Seymour Street LLC. Accordingly, any claim by MRP that there is an actual controversy and that the court must declare that it is the sole member of Seymour Street LLC or the owner of the property is meritless. And third, there is no actual controversy that there was never a conveyance of interest from the Michigan Republican State Committee or the state party to the MRP trust, or that such conveyance would have been invalid for lack of legal consideration. Plaintiff asserts that the, quote, purported conveyance of any interest in Seymour Streets LLC belonged to the Michigan Republican State Committee or the state party because the original, again, folks, just to clarify, Michigan Republican State Committee was the old name of the state party. They're one and the same thing.
Yep.
No consideration was ever provided to the Michigan Republican State Central Committee or Michigan Republican Party for any transfer of an interest in the property. There is no actual controversy as to these assertions for 2 reasons. 1, these assertions are factually inaccurate, and 2, these assertions are premised on an incorrect statement of law. The original sole member of Seymour Street LLC was the old trust. Neither the State Central Committee nor the state party ever possessed a membership interest in Seymour Street LLC, nor did either of them ever own the property. And even if the state party or the state committee had owned the property or possessed a membership interest in Seymour Street LLC, any conveyance into a trust could not have been invalid for lack of consideration. Because trusts originate in gifts, black letter trust law does not require legal consideration. Do you explain that, Matt?
All right. Well, let's break it down, because this is like kind of the basics of why you don't do this without, legal representation. So I'm trying to pull it up a bit bigger on my screen. Hang on 1 second. And what it says is you can't say that if I give a property to a trust, okay, I don't need to get something back. Okay, there's now a legal consideration. It's how I fund my trust. If I have one for my kids, then I put money in a trust, and that's okay, right?
Yeah.
There's
a footnote here that says this too. The footnote. If property is transferred in trust, it is immaterial that no consideration is given by the beneficiary to the transferor or to the transferee. It is immaterial that no consideration is received by the transferee other than the property so transferred, and that no consideration is received by the transferor. So, yeah.
Right. Their whole argument is, well, we think the property was originally owned by the Michigan Republican Party, and by transferring it to the trust or transferring it to the LLC, you did that with no consideration, and that's unlawful. And they come back and say 2 things. Number 1, that's factually inaccurate. The trust always owned it. It was never owned by anybody else, which is clear from the record. And then they say, just furthermore, if competent legal, how about maybe just a licensed attorney more than the guy who was going to be a fact witness. But then they say, even if what you say was true, which is not, it's okay to transfer something to a trust without consideration back. That's okay. It happens all the time. And if you understood how trusts are created, you wouldn't say something like that. So this is just, this is just a two-fisted beating on this argument that they, and their argument is actually stupider. If you read the complaint, the complaint says things like, well, they showed it on their balance sheet, so they must own it. Or I think the executive director, Mr. Koppes, said, well, why, if you pledge property for someone else's debt, it must be owned by them, which is completely wrong. It happens literally all the time.
I do want to add the point that very conveniently on the November balance sheet, for the first time in Kristina Karamo's tenure, they added the building and depreciation onto their balance sheet to use this as the legal argument for this part of the lawsuit. So, like, you could go back to August, it won't be there. But if you go to November, oh, poop, there it is.
But again, there's all kinds of arguments you could make, and they have nothing to do with the conveyance of real estate.
Yep.
I show the Brooklyn Bridge on my balance sheet. Doesn't mean I own the Brooklyn Bridge. I put a sign on the Brooklyn Bridge that says this belongs to Matt. Right? Yeah. I trademark the name Brooklyn Bridge. Do I now own the Brooklyn Bridge? No, none of these things are true. And if you vet this set of facts through an actual outside counsel that's competent, as John King mentioned, they would say, don't do this. This is wrong. Yep. You're going to get thrown out of court and you're going to owe money, which we're going to get to that in a second.
Yep. Tamara Feldhouse on YouTube says, I wonder if Hartman got his legal advice from Owens. I don't know what that's in reference to, Tamara, but you're welcome to elaborate. Anyway, moving on.
Robert Owens is a person who's been sending out a bunch of emails. Robert Owens, JD. He's got a long and sordid history in the state of Ohio, where he's from. I don't believe he's a current member of the bar.
Disbarred as of his convictions for the 6 felonies for stealing client funds totaling $123,000. He's also $120,000 behind on arrears of child support, and there was some hookers in his past and his divorce documents as well.
Well, there you go. So for the dozenth time, they say there is no actual controversy that there was ever a transfer of property or membership interest from the MRP or the state committee to the Michigan Republican Party Trust. And if there had been, there is no actual controversy that such conveyance would have been improper. In addition, as has been demonstrated above, there is no ambiguity. The state party trust is the sole member of Seymour Street LLC. Again, we've heard this 100 times now. I'll move on. B, this is a second argument they're making here. Plaintiffs' claims regarding the property are not ripe for adjudication. In addition to the lack of any justiciable controversy, plaintiffs' claims regarding the property are not ripe for adjudication. In Vistion Corporation, the Court of Appeals also affirmed the trial court's grant of summary disposition on the grounds that the breach of contract claim was not ripe. The doctrine of ripeness is closely related to the standing doctrine in that it focuses on the timing of the action. The ripeness doctrine requires that a party has sustained an actual injury to bring a claim. A party may not premise an action on a hypothetical controversy. Here, plaintiff has not sustained an actual injury. On the contrary, under the plain language of the Michigan Party Trust Agreement, the Michigan Republican State Committee may override certain decisions of the trustees deemed to be in the best interest of the MRP by a 3/4 vote, and other decisions of the trustees, such as, I think when they say here, the MRP trust, I think is what they mean. Is that right? And other decisions of the trust, such as those relating to the trustee's ability to 1, sell, convey, mortgage, grant a security interest in, pledge, lease, exchange, or otherwise dispose or encumber an interest the trust property. Could have just said sell the building. 2, repair, manage, improve, etc. the trust property. 3, revoke the trust. 4, amend or not amend the trust agreement by a unanimous vote. In other words, there's a clear path for the plaintiff, Kristina, to override any decision of the trustees. She could have gotten 3/4 of the state committee members to override it, but she didn't.
Or it could be dissolved with 100% vote.
Yep.
Right. And that's a key point. The key point is, if you think, because her argument to state committee members were, this is an asset that we should use to do something else with, use the money another way. There is a method to do that. There's a methodology to do that. You have to do what the trust agreement says you have to do,
Get
She doesn't
3/4
have
vote.
close to support for that concept. What this woman has demonstrated repeatedly is that she doesn't like getting prior authority to do the things she needs to do, even if the documents say so. So here's another one.
Yeah.
Get a 3/4 vote of the state committee, and you can change the terms of the trust agreement. You didn't do that. You didn't try. You didn't ask.
Yeah.
But you just went into court and said, I don't need to try. I already own it.
So
Yeah,
Matt,
this is her answer to everything. I'm the dictator. Everyone doesn't agree with me. They're the deep state.
Right.
Matt, I have a quick question for you.
Oh.
Are there any repercussions or ramifications for the fact that because they entered this lawsuit as the Michigan State Republican Party and they didn't take any vote, they didn't consult, they didn't discuss, they didn't bring it on, but then they had a lawsuit filed where they named plaintiffs that didn't know they were plaintiffs to a lawsuit?
Oh, so in the process of a lawsuit, because we are on like stage 0.1, right? So stage 1 would be, and this is what they talked about, is the discovery process. But the discovery process is a two-way street, right? It's not just you get to ask the other side what they know, it's they get to ask you what you know. So in the process of that, the attorneys for these two entities would say simply, please demonstrate to us your authority to have entered in this lawsuit. And she couldn't do it because she never got it. And that would be simply another grounds to throw it out. That's a later stage. You won't get there because you're going to get it thrown out here. But yeah, it's called ultra vires. It's against it's a corporation acting outside of its authority. It's sort of like, if you have an LLC that says the manager needs the members' approval for this, and the manager never does it.
Yeah.
Not only could the other side say you didn't have the authority to do that, which is what's gone on here, but you also, if you ever wanted to, the members could go after the manager saying, hey, you did this without my authority, which this has been a repeat problem. Yes, exactly.
Yes, that's my follow-up. So can state committee members get legal representation and join on the defendant side of this, saying that we never gave the authority to even have this brought in our names? Because when we get down to page 18, there's going to be a reason why.
Yeah.
Right. The answer to that question is yes. You could file what's called an interpleader and say we're another group of people coming in, the 107 members of the state committee or whatever percentage. And this is required to be authorized pursuant to our bylaws, pursuant to 1, 2, 3, 4, 5. It was never done. So, Your Honor, you should throw this out because this person doesn't have the authority to do that. You're not going to get there because, like I said, it's
no, This is garbage. It's garbage.
But do you have that authority to do so? Yes, absolutely.
Thanks, Matt.
Yeah, maybe at the end when there's sanctions, then the state party members and as individuals can sue, as a group of individuals can sue Kristina.
Yeah, there's one more thing you can do. We'll get to it when we get there.
All right.
Beautiful.
Anyway, so that's what this argument is all about. You just explained. She could have gotten this 3/4 vote. She didn't. Plaintiff has made no attempt to take those steps and instead has concocted a hypothetical controversy regarding the ownership of the property in order to have full control of the property. But until plaintiff sustains an actual injury, plaintiff's claims regarding the property are not ripe for adjudication and therefore summary disposition is appropriate. And now, again, we get back to this stupid trademark garbage. There is no controversy regarding the Republican Party trademark. Plaintiff asserts that the court must act to declare the Michigan Republican State Committee, the Michigan Republican State Central Committee, the Michigan Republican Party, and the Republican Party of Michigan having the exclusive right to the name Republican Party. The MRP Trust does not contest that the Department of Licensing and Regulatory Affairs registered the service mark for the Michigan Republicans and that this mark belongs to the Michigan Republican Party. Accordingly, there is no actual controversy with regarding to this assertion, and summary disposition under the court rule is appropriate. By the way, folks, the real reason why this was in the suit is because Kristina wants to send out cease and desist letters to county committees, to Michigan GOP Watch, et cetera, saying you can't call yourself the Republican anything, which they actually can. Unfortunately, whatever decision the court's going to make is not going to stop them from doing that, because they're going to still, the court said that there's no controversy here and that it's our trademark, blah, blah, blah. They're going to still do that garbage, okay, if they're still in power and able to do so.
Yeah, but let's talk about like the basics of litigation, right? The basics of litigation are, if you want something to impact somebody, right? You want the court to have jurisdiction, you must name and serve that person, okay? You don't have the ability to go in and file this lawsuit and have the judge say, this is your trademark vis-a-vis the trust, and therefore that other relief against other parties is automatic. If you want to go tell the MIGOP Watch or whoever, you can't use our name
Oh, I
anymore.
know. I'm just saying they're sending lots of nasty threat letters.
You have to sue them. And here's the thing. Number one, you can't. Number two, it costs money to do so and you don't have any. Number three, then they make a very, very different claim that the trust doesn't care. The trust doesn't care that you have this registered service mark, but it's descriptive and it's a word mark, and there are lots of defenses to it. And if you want to prevent them from doing so, like in the plain, I don't know if it's discussed here because I don't think it is, but in the existing complaint, they said, we're this exclusive group that can identify party committees, right?
Yeah.
Which is this backhanded way of trying to control county parties. But
Districts and counties.
Districts and counties. But who didn't you name as a defendant? Districts and counties.
Yep.
Yeah.
You didn't do any of those things, because if you do, now you have 83 people knowing what your plan is. So you tried this kind of backhanded, legally ineffective way to try to get this done. And for what John just posted right there, and for this reason, it falls completely flat on its face.
Yeah.
Yeah, they're trying to backdoor the Kalamazoo and the Hillsdale decisions.
Yeah.
And Macomb.
But that's what this is. That's what this goes to. When people keep thinking that they're not coming after counties and they're not coming after districts to stack committees to stay in power, that's what the end game for all these stupid things are.
Yeah. That's why they had the conflict resolution committee, folks. What would it exist for if not to meddle in county affairs? All right.
Until it was
A
dissolved.
couple of comments in the chat. Brent Leininger on Facebook says, phenomenal documentation by an incredible legal team and outstanding attorney. I assume you're referring to the attorneys on this document, Brent, not our counsel here. And on Rumble, on Rumble, Hitman 48 says, the District 4 vice chair says there is gun running, drug running, and human trafficking from the Sekia Weiser building.
Oh,
Why would
yeah.
they want
The
the building if
defamation
that
is
is
crazy.
indeed going on. Yeah, I mean, I read that. Obviously, I can't verify what the District 4 vice chair might have said.
It was Sabrina Pritchard Evans. I've got screenshots of it, and it's disgusting what these people are saying.
I can tell you what. Why don't you try going after Ron? How much you enjoy responding to the attorneys of Ron Weiser? He is a very serious and experienced businessman who has access to very, very good attorneys. I would recommend to everyone watching, try not to defame him, because if you do, it's going to be really ugly on your behalf.
Oh, it's
I imagine Ron Weiser cares about his legacy. I'm just guessing.
Yeah, I'm thinking he probably does.
Yeah, but this also, I think, but to that point, it highlights how absolutely unmoored from any semblance of reality people are. They don't care about facts. They don't care about substantiation. They don't care about the law. Anything we're talking about tonight, they don't care, folks. They're nuts. They are occultists. They're fanatics, and that's the kinds of things they'll just say. They know they don't have any evidence. This person didn't go to whoever said this and said, "Oh, really? Can you prove that?" It's absolutely insane.
Adam, there's a standard that attorneys have to follow. They have to do reasonable investigation and diligence in the facts behind a lawsuit. An attorney cannot simply take a bunch of information that a client gives them, slap it into a lawsuit, and file it. That is sanctionable, not just of the plaintiff, but also of plaintiff's counsel.
Yeah.
Okay. Now, in this case, this one's so preposterous because the facts that they lay out prove the other side's case, right? They lay out, here's a title commitment. It shows the property was owned by Seymour Street LLC. That proves the other side. So you didn't get, as you're indicating, you didn't get that basic level of due diligence that came along with, that supposedly comes along with filing a suit. And that's the problem, because if you take this to an outside attorney, they're going to run it by somebody and they're going to look and go, we don't have enough factual information to do this. And what you've provided us doesn't doesn't merit filing a case. But
yep. All right, let's keep going here. We're almost through this motion. Finally, this court should dismiss plaintiff's claims regarding Seymour Street LLC and or the trust's use of the assumed name as moot. A court may not decide moot questions in the guise of giving declaratory relief because moot cases present only abstract questions of law that do not rest upon existing facts or rights. As explained above, the LARA certificates, that's the Licensing and Regulatory Affairs certificates of assumed name, were not renewed and expired 4 days ago. Accordingly, plaintiffs request for declaratory relief that the state party trust be prohibited from using the name or trademark Michigan Republican Party, and using the trademark is moot, and this court need not decide the question of whether the Seymour Street LLC and or trust may continue to use the assumed names. In sum, there's no actual controversy that state party or its committees have exclusive rights to the state party service mark, and 2, that the MRP cannot, and more importantly, does not own the property. 3, that the Michigan Republican State Central Committee cannot, and more importantly, does not own the property. 4, that the sole member of the Seymour Street LLC is the trust. 5, that the owner of the property is owned by Seymour Street LLC. I think might be a typo in there. And 6, that neither the state party committee nor the state party ever had a membership interest in Seymour Street LLC. Accordingly, summary disposition under court rule is appropriate, as this court is without jurisdiction to enter declaratory relief for lack of any actual controversy. In addition, plaintiffs' claims regarding the property are not ripe for adjudication, so that's just a restatement what we already heard. 2, dismissal of plaintiff's declaratory judgment claims regarding Seymour Street LLC and the property are appropriate under the court rule because there's no genuine issue of any material fact that the state party trust, as sole member of the LLC, is owner of the MRP headquarters. This sounds a lot like what we just read through, so I'm going to skim right over this for a second here, folks.
It's very, very similar. What it says is the law does not provide them for relief. That's part 1. And then this part says basically the facts do not provide them with relief either.
Okay, yeah, gotcha. Okay. But they're the same set of facts anyway, so.
Same set of facts. And it's like just double dipping. You're like,
same thing here. They can establish a prima facie case of title. Yeah. Okay, so.
I mean, there's all kinds of parts in there that are just defy not like.
I do want to read this. I do want to read this summary here because there's some juicy footnotes here. Here, plaintiff cannot establish title to the property. Indeed, the exhibits attached to plaintiff's own complaint demonstrate that the property is owned by Seymour Street LLC. See 2 footnotes. 6. Plaintiff asserts that the affidavit of interest signed by Bobby Shostak as chair of the Michigan Republican Party attached to its complaint as Exhibit 7 is somehow invalid because Mr. Shostak lacked authority under the Michigan Republican Party bylaws to execute the affidavit. Under the current version of the Michigan Republican Party bylaws listed on its website, the chair shall sign all documents. Bylaws of the Michigan Republican State Committee, amended February 8th, 2020, available at yada yada. Accordingly, it is unclear how the chair, even in 2011, would have been prohibited from signing an affidavit, especially given that the affidavit clearly states that it is based on Mr. Shostak's personal knowledge of the facts based in the affidavit. On the contrary, Mr. Shostak's execution of the affidavit of interest in his capacity as state party chair is likewise an admission by the plaintiff that Seymour Street LLC and not the state party owns the property. Also, plaintiff's own exhibits negate this claim in paragraph 94 that this court must declare that the property is not pledged to Defendant Comerica Bank and is free from any claim by the same. So there you go.
Adam, without getting too deep in the weeds on that one.
Yeah.
I borrowed money from my bank. To pay for my house. The document that creates a lien on a piece of property is called a mortgage. Everybody on this call knows what that is. In their own filing, is there a mortgage on the property in Seymour Street in favor of anybody?
Nope.
There is not. And by their own admittance, they attached a title policy and it shows nothing.
Clear title.
It just boggles the mind.
Yeah. On Rumble, KLSC85 says, it seems like we're shooting ourselves in both feet with an M61 Vulcan cannon. Well, define we. I mean, Kristina. Kristina is shooting the party in both feet. Charlotte Cosmic says, lol, which normally means laughing out loud, but she says, low on liquor. Wow, this is crazy. Yep. All right. No amount of discovery will change the facts and law as they exist. The plaintiff does not and has not ever owned the property. Accordingly, plaintiff cannot carry its burden of establishing a case of title and summary disposition in favor of MRP Trust is appropriate. B, summary disposition is appropriate because the Michigan Republican Party Trust has presented affirmative evidence proving its rights to the property. Summary disposition of the plaintiff's claims is also appropriate because the state party trust has presented affirmative evidence demonstrating the party's ownership. In addition to the exhibits provided in the plaintiff's complaint, the MRP Trust has provided additional evidence demonstrating that the property is owned by Seymour Street LLC. Exhibits 2, 3, and 8. We'll look at those briefly at the end. The MRP Trust has also submitted evidence that the sole member of Seymour Street LLC is the trust. Yep, we'll look at that. Again, we've been over this a million times. We'll look at the exhibits. Indeed, the MRP Trust has documented every step and every transaction. Accordingly, summary disposition is also appropriate under the court rule as to plaintiff's claims pertaining to Seymour Street LLC or the property. Finally, this court should impose sanctions on plaintiff for knowingly filing this frivolous action. As noted above, plaintiff's current chair herself has acknowledged that the property is owned by a trust, not MIGOP, Exhibit 16. We'll look at that one for a moment at the end. That's the email that Kristina sent out to everybody answering our questions. Therefore, beyond simply dismissing this complaint, the court should sanction plaintiff and its attorney for the improper conduct in filing an obviously frivolous lawsuit. See Court Rules A, B, and C. The purpose of imposing sanctions for asserting frivolous claims is to deter parties and attorneys from filing documents and asserting claims and defenses that have not been sufficiently investigated and researched or that are intended to serve an improper purpose, i.e. sealing a building.
No, not that. No, it is a fishing expedition. You cannot file a suit and demand discovery to get documents to try to prove something else. And not only is that what they tried to do, it's what they admitted they tried to do. We need to file this suit so we can get the documents we asked for. That's not why you file a suit. That's by definition frivolous.
MCL 600.2591 provides that, quote, upon promotion of any party, if a court finds that a civil action or defense to a civil action was frivolous, the court that conducts the civil action shall, not might, shall award to the prevailing party the costs and fees incurred by that party in connection with the civil action by assessing the costs and fees against the non-prevailing party and their attorney. MCL defines frivolous to include an action where either of the following exist. And those eithers are the party had no reasonable basis to believe that the facts underlying the party's legal position were in fact true. 3, the party's legal position was devoid of arguable legal merit. The MCL MCL citation. Similarly, the court rule provides that if the court finds on motion of a party that an action or defense was frivolous, costs shall be awarded. I think, by the way, the problem is, but they have discretion on whether or not they find the motion to be frivolous. So they still have discretion, but once they find that a motion is frivolous, they are mandated to provide costs.
Yeah, they're bound by it.
Yeah. The court rule provides that this court is authorized to sanction a party for submitting documents that contain claims that are not warranted by existing law or good faith argument for the extension, modification, or reversal of existing law. Further, this court, quote, has inherent authority to impose sanctions on the basis of misconduct of a party or an attorney. And notably, sanctions may be imposed upon attorneys and even represented parties. Footnote, because plaintiff is an unincorporated voluntary association, the sanctions may be awarded against each member of the Michigan Republican State Committee individually. See MCL 600.2051, paragraph 2.
2, yep. And that law has been on the books since 1963. And the precedent for that was just again reaffirmed in the Hillsdale case today.
Yep. Well, one week ago today, but yes.
Well, the discovery of the documents
yeah.
for us today. Correct. Yes.
Yeah. So, folks, think about this for the state committee members. They are financially liable for this bullshit. What do you think they're going to do? I mean, granted, some of them are, obsessed enough with this Kristina narrative that they'll go along with this, but most of them are going to look at this and say, "This is not what I signed up for."
Do the math for them, Adam. Do the math for them.
Well,
you owe $52,500 on the Hillsdale matter, give or take. There's 100, give or take, state committee members, a little more. but let's say 100 because I like the math. You owe from that thing that you probably didn't know about until now, you owe $525 each and every state committee member.
Yep.
Okay.
This
one right here.
Wait, hold on a second, Matt. Because in the Hillsdale case, there was, the parties to the suit were, these two competing Hillsdale County factions.
Right.
If they have an attorney, it's going to cost them $50,000. How much do you think the Comerica Bank's attorneys are going to have to bill them for?
Yeah. Oh no, we're just getting it.
Yeah. Get to that math, Matt. It's beautiful.
This is 3 times that. Maybe.
I think it's going to be closer.
And then Comerica files its own. Yeah, exactly. Now wait a minute. See, John raises a very good point because we're not done yet. So let's do the math for each and every one of these pieces. On Hillsdale alone, you owe $525. On this one right here, just for this piece of paper that was filed, it's probably something on the order of 75 grand, maybe a little more because of all the background, maybe say 100 grand. So that's $1,000 you owe for this piece of paper right here. Comerica, that's another $1,000. The amount of money you owe Comerica, 550 grand, that's $5,500. Are there other things out there that you owe that you aren't aware of? Mackinac, anybody else paying back Jim Coppas's wife for another $1,000? So now you're talking $8,000, $9,000, $10,000 per person. If you are a state committee member watching this,
and remember, folks, if anybody else in the party doesn't pay, you're still liable for that anyway.
Yeah, if you leave, it doesn't matter. It follows you during your term. It's at the date of. So if you resign after this, tough biscuits.
Yeah, you're still paying it. You're still paying it. So did you sign up for this? Is it when they sat you down? Now, I know particularly some of the committee members on the budget committee, and I know they've asked these questions and gotten no answers. They were presented with a series of things that they could do. One state committee member said, yeah, what about like this 5th option, like raise money and pay off the loan and not sell the building? And he was basically told, no, in certain terms, be quiet, sit down, because that's not what we're doing. So that's what you get.
A couple of other chats here. On Rumble, KLSC85 says, Will Rogers once said he didn't belong to any organized party. He said he was a Democrat. Today, Mr. Rogers could claim he belongs to the MIGOP. UP Melanie says, actually asked a question. If state committee members have to pay sanctions and attorney fees, does that include district chairs too? Probably.
Yeah, district chairs. Yeah, they're part of the body. Yeah, they're part of the body. Absolutely, they will be.
And she also asks, and did Comerica respond to the lawsuit yet? Apparently they have, but we haven't gotten the document just yet. However, going back to John Dunlap's comment, just wait for the Comerica claim, not the motion, the claim, the counterclaims, I think what John's referring to. Another thing, folks, if you're holding for depositions, you're going to want a lawyer, and they're very, very expensive.
And that's the thing that people aren't realizing.
It's the ancillary. I have a proxy to pay these fees for me. Well,
you wish, roll it.
Yeah, but that's what people aren't realizing is the unassumed costs that will go with this, which are going to be your own representation to get you out of this tangled mess. When in actuality, you never knew about this in the first place. This was all done behind your back.
Yep. Right. On YouTube, Leanne Oman says 1963 was the year the state of Michigan gave up its Republican form of government. I'm not sure if you're referring to the rewriting of the state constitution, Leanne, but there you go.
Well, I mean, this is the stuff that has to be pushed back on, is because when these questions were raised on the call last week, you, Adam, myself, Warren, you were listening, were told unequivocally this is not true. And here it is in black and white with legal citations. Mr. Koppas, Mr. Hartman, who did you explain this to? Did you explain this to the state committee members before you filed this suit? That there is a risk that you will be on the hook personally for sanctions, legal fees, and the debt. And I know the answer to that question, and it's no.
Yep. They lied to you.
They lied to you.
And you probably have it in writing from somewhere, but if not, I'm sure others do. Nudge, nudge, wink, wink. Anyway. Let's finish this off. Plaintiff's claims are frivolous under MCL 600. Yada yada and violate court rules because plaintiff's claims are devoid of arguable legal merit. Footnote: this is not the first time that Ms. Karamo and her attorney have filed a lawsuit based on a legal theory devoid of arguable legal merit. Karamo v. Winfrey, unpublished opinion of the Wayne County Circuit Court, issued June 12, 2023. In that case, the court awarded sanctions against Ms. Karamo, Mr. Hartman, and others because it found there, quote, was no reasonable basis to believe the facts underlying their legal position were in fact true. The same result should obtain here. John Smith says, I can't wait until you state committee members pay for the Hillsdale BS. There you go. Where were we? Oh, yes. First, plaintiff's own complaint and exhibits acknowledge that the owner of the property seems... Okay, we've read this all before.
Just a nice summary.
Conclusion. Nothing in the plain, unambiguous language of any of the documents provided by plaintiff in this complaint or attached to this motion creates an actual controversy as to the ownership of Seymour Street LLC or the property.
Back up for a second. Back up for a second. Okay, because there's just the hilarity just ensues, right? So they just have to throw this little thing. Here we are. What are we, 19 pages in. Go ahead.
Yeah. This is not really entirely relevant to the case, but just kicking a corpse right there. That's what they're doing.
Right.
Yeah.
So you
just
say
so you know, Your Honor, these people have been sanctioned before.
Well, no. Back up a little bit, because there's a section. If you go back up a few, where it starts with further in the May of 2023, the plaintiff's executive director forwarded invoices for utility.
Okay, I'm sorry. I should not have skipped over this, guys. Yes, let's read this. Or you want to read it, Matt?
Yeah, it basically it says forwarded invoices for utilities, lawn care, and snow removal for the property to one of the trustees of the MRP trust. Performing him, the attached invoices for the building need to be transferred so the trust paid managed the trust. So this building that they claim they own, in May of 2023, they sent the bills to the trust saying, pay these bills because you own the building.
Yeah.
What?
Yeah, pay your... Well, and the funny thing is, that goes back to the story where the electricity got shut off, right? She got the bills and didn't pay them, and then the electricity shut off and the doors were wide open. The cops had to find out.
Right. If you own the building, you pay the bills. You sent the bills to somebody else, which is an admittance that you didn't own the building, which you don't do. You don't own the building.
John Smith says both cases, the trust and Hillsdale, the same attorney too. On Rumble, UP Melanie asks, is there anything that state committee members who support the removal of Kristina can do to protect themselves?
Yes. Show up at the meeting. Show up at the meeting. And I'll just put it that I can show up at the meeting.
All right. So conclusion, nothing in the plain, unambiguous language of any of the documents provided by plaintiff in its complaint or attached to this motion creates an actual controversy as the ownership of the building. The trust has clearly demonstrated the property is owned by Seymour Street LLC and that the sole member of Seymour Street is the MRP Trust. None of the plaintiff's vague accusations or wild theories can change that simple fact. Accordingly, the MRP Trust respectfully requests that this court grant summary disposition and dismiss all of plaintiff's claims regarding Seymour Street LLC or the property with prejudice, as well as plaintiff's claims regarding the certificate of assumed name as moot. The MRP Trust further requests sanctions pursuant to MCL and MCR to include reasonable attorneys' fees and costs, dated 2 days ago. Also, footnote.
Read footnote 10. Footnote 10 is the good one.
In addition to being frivolous, this lawsuit is interfering with the trustees' ability to fulfill their fiduciary duty to manage and preserve the trust assets. Even after this case is dismissed, the trustees reserve all rights and remedies against any party or person that engages in such interference. The trustees further note that members of unincorporated associations may be held personally liable for the conduct of the association. See MCL 600.2051. That's their way of saying, we're not done, guys. You might get sanctioned for this, and you might get sanctioned for a lot more.
They're coming.
They're coming.
Yeah, they're coming.
Jay Michaud asks, so what should other political party committees at all levels do to prevent this kind of personal liability of its committee members? Is there a form of...
The answer to that question is don't do dumb stuff. It's the Barack Obama, I think, don't do dumb stuff. The reason why this doesn't happen generally is because political parties, well, first of all, political parties don't generally hold a lot of assets, right? They have cash coming in and out to support campaigns, right? But that's not a thing. Don't do dumb stuff. When you're party, when your committee is out there saying we're going to do X or Y or Z, or you hear that they do, you take action immediately to go in and stop it from happening. Okay, when people think they're going to be cute by leaving the Hillsdale people on the website, don't select chairs who want to be idols. That's a possibility, but that's the first thing that you do. The corporate form of a state party is not changed for a long time. So it's not, you don't form an LLC, you don't form a corporation to do so. And that's true at all levels. So when I was chair of the Wayne 6th, we are a county party, and that's how our paperwork is filed. So how do we get protection? Just don't do dumb things, right? Don't do dumb things that put yourself in the way of this exposure.
Yeah.
But that's with
John
every
Smith's question
board,
about
right?
statutory
That's
members,
whether,
Matt, would I be correct that they wouldn't be liable unless they resigned? But they could always resign, right?
No, statutory members
could have resigned.
It's an open question. It's an open question because there's also ex officio members, and I don't believe, in my opinion, that they're subject to it. I think it's voting members of the state committee, the 107 or whatever number there are. I think those people are on the hook.
Okay.
correct.
All right. Let's very quickly go through the exhibits because that was the meat of it. But we've got what else do we have here? This is the affidavit of Eric Doster. And again, I'm going to go quickly through this. He said, I'm an attorney. I was the counsel for decades. And he's verifying all the things we just talked about. So there's no reason to read through this word for word. But you guys get the idea. And you can read this if you want. I sent it out in the email blast for today. And it's also, I can put the link in the description for where to find this, but it's also linked in the email blast I sent out today, which most of you probably have seen. So there's Eric Doster's affidavit saying all the things that we just went over. The operating agreement of Seymour Street LLC. This is all the terms of Seymour Street LLC, who they are. All this, again, all this is just to corroborate all the things that they just said. Then we have, let's see here. These are just pretty standard documents. Exhibit A, member, Michigan Republican State Party Headquarters Trust. That was the old trust. Initial capital contribution, real estate located at 520 Seymour Street, sharing ratio, interest in LLC 100%. Authorizing resolution. This is for, I believe, the transfer from the old trust to the new trust. Whoop-de-doo. This is the old trust agreement made in 1987. Spencer Abraham and Denzel. Wow, I was going back a long way. Was Spencer Abraham the chair? Yeah, chair of the party and the treasurer. There you go. So there's the old trust document. And then next we have authorizing resolution for the trust to have purchased the building at 520 Seymour Avenue right there. That's the old trust documents, 2005. This is a notice from a law firm. Thank you for advising us that McKinley Financial Partnership LLC, that's Ron Weiser's company, has already tendered the $250,000 deposit on behalf of the Michigan Republican Party State Party Headquarters Trust. Attached, please find fully executed materials of the following documents. This is all the stuff they were talking about. And there it is. There you go. Mortgage. There it is. And we'll see what else we have here. There's Eric Doster's name again. Eric Doster was with the state party as their general counsel for like 20 plus years, guys. He knows this stuff up and down. Filing endorsement, articles of organization for Seymour Street LLC. McKinley, care of Lynette Butler. There you go.
The deed.
There is the LLC document. There's the articles of organization for Seymour Street LLC. There's their ID number. There's a warranty deed right there.
That's the deed.
Huh? Yep. Property transfer affidavit. There you go. Michigan Republican Party Trust Agreement. Made effective December 5th. I bet they'll say every single thing that they just said it was going to say in their motion.
Right. When you get to the next one, it's got an interesting nuance.
Okay. Lease between landlord Seymour Street LLC and tenant, Michigan Republican Party, dated January 1st, 2009.
And let's go in the Wayback Machine.
Okay.
Wayback Machine, the state chair said to a large crowd that she was being fiscally responsible by terminating the lease. If you terminate the lease, it isn't on property that you own.
Correct.
Oops.
Over and over and over.
On Rumble, I'm sorry, on YouTube, Iceman 99 Turbo says, play stupid games, win stupid prizes. Been saying that since last convention. On Rumble, Hitman 48 says, that's what they get for removing me for wearing a t-shirt they didn't like on December 2nd. I know what that's about. Charlotte Cosmic responding to UP Melanie says, yes, the party that gets jailed and fined thousands of dollars. Courts make money. Election 24 has no money. Sad. Interesting. All right. So anything else we want to look at in this lease
keep going.
agreement?
I want you to go, not in this document. Go to Exhibit 16 because you've been teasing it.
Go to the email, baby.
Okay. All right. So there's another thing about the lease. Yeah. Okay. We'll skip over the lease. Oh, this is gonna be a big document. Let me start doing page down here. Lease.
Yeah, it goes on. There's 2 leases and 2 trusts, so it's way down there.
Okay, after of interest in real property, under trust agreement, other lease. Here we go.
Page 149.
All right, I'm getting there.
These aren't
Here we
serious
go.
people.
Email. Let's see. From Michigan Republican Party, communication at migop.org. Date, March 13th, 2023, to Jason Cable Rowe. Dear precinct delegates, our MIGOP team is headed into our 4th week of transitioning. I want to share a progress update with you. Our team, by the way, you guys know who Jason Cable Rowe is, right?
Former
He's a consultant.
Yep.
Former state party executive director. He's a never Trumper, but never, and therefore I'm sure he's got a political axe to grind here. But so what? This is an authentic document. I got this document.
Everyone
I got this email. Yeah, every precinct delegate got this email. If she had your email address, you probably got this email from Kristina on March 13th.
That is correct.
Our MIGOP team is headed into our 4th week of transitioning. That's kind of a statement right there. Our 4th week of transitioning. I want to share a progress update with you. Our team is bringing a much-needed innovation and infrastructure changes to MIGOP to ensure we are victorious in 2024. By the way, I had a question for you, gentlemen, because Patty and I have disagreed about this. I think it says something that she always calls it MIGOP. She even pronounces it MIGOP. It's never Republicans. Never talking about our Republican Party. I think that says something about her, Doesn't that seem weird to you?
No, even better yet, they're constitutionalists. You're not Republicans, you're constitutionalists. That's what they want. They want constitutionalists. And if you go and look for what the constitutionalist is, there is a constitution party.
No.
Right?
I'm just asking. Doesn't it seem weird how she always calls it MIGOP? It's
No,
always
100%. But it's never Republicans. It's not Republicans about anything.
Yeah.
Right. Yeah, no, it's and first of all, anybody with any basic knowledge of how to market a product would not, unless I'm selling glue or tape, I don't call it MIGOP.
Yeah.
Stupid.
She's trying to run away from the brand because she's not a Republican.
She's not a Republican.
Not at all.
Our MIGOP team is heading to. Okay, I read all that. There's much work to be done as servant leaders. Always the grandstanding on the religious stuff. We must now build the MIGOP from scratch. With the 2024 elections about 21 months away, this seems to be a monumental task for sure. As we consider the new level of PD-focused systems and services being constructed, the status quo of MIGOP ineffectiveness is in the process of being replaced with synergy between MIGOP PDs, county and district parties. We are planning this design to be transitioned to our children and grandchildren's future, from inheriting tyranny to inheriting usable, God-given, unalienable rights. It's just a constitutionalist word salad.
Yeah,
it's like the world's worst Mad Lib.
Yeah,
just great words. Nothing matches.
Yeah, Patty says Copas calls it MIGOP too. Yep. All right, transition update. One of the questions we frequently receive is regarding the building used by MIGOP in Lansing. Many businesses and nonprofits are moving toward a working model whereby volunteers and employees work remotely while having access to satellite locations. That's by the way, terrible idea, folks. COVID was a disaster. Working from home means you can jack around all day long and get away with it. Work at the office. Satellite locations smaller than the past large corporate buildings, but also decentralized in location allows this is also bizarrely ungrammatical, allows volunteers and employees distributed throughout a large geographical area to have access to a facility containing support resources, ability to hold meetings, and the like. The cost for which will likely be equal to or less than the large building in Lansing that they pay $1 a month in rent for and can sublease out to other organizations to pay for their incidentals. The building in Lansing is owned by a trust, not MIGOP. Meaning, a board of trustees, including past MIGOP chairs and potentially others, own the building people think of as the MIGOP building. Meaning, our new MIGOP team does not have control over that building, and to use it, we would have to pay approximately $12,000 a month. This does not include potential repairs that will be needed because the building is owned by a trust and not MIGOP. It is not something we can liquidate to help pay off the debt our team inherited. Whoops.
Stop right there. Stop right there.
Game, set,
We were told,
match.
we
Sanctions.
were told on
Sanctions.
a call. Now, beyond that, Warren, beyond that, we had 100 people who took their time out on a day. I'm on vacation. I'm actually in the Ronald Reagan Presidential Library taking this call, and I have this team of clowns tell me the exact opposite, that they're liars. They're duty bound to determine if they own the building and can liquidate it to pay off this debt that they inherited from Ron Weiser. False. And here you are earlier saying the exact opposite. It's offensive to everyone's time that we had to listen to you concoct those lies, knowing that you said the exact opposite, which was correct months earlier.
Yep.
Yeah, she's not a truthful person.
Yep.
I keep telling people this.
Real quick, on Rumble, that comment by Hitman48 has been an update. Charlotte asks what that t-shirt says, and Hitman48 says, ask me why I'm voting for Matt DePerno for state chair. Remember the green shirts. And then he says, Charlotte says, oh, and then he says, covered under the First Amendment. Well, I mean, a couple of things, Hitman. First, in a private meeting, the First Amendment doesn't apply necessarily. But secondly, in my humble opinion, and folks in the chat can disagree with me if you like, I don't think things would have been very different with Matt DePerno as state chair. Fundamentally, he A, doesn't know how to raise money any more than she did, and B, has his own bad history of filing bad lawsuits too. But we can talk about that another day. Anyway, moving on. Instead of paying a lease/rent to a trust that is claiming we can't even see the trust documents, and instead of attempting to repair the building that does not belong to MIGOP, we shall not be making use of this building, given that to do so does not represent best use of fundraising dollars. Moreover, there are better ways to use your contributions to facilitate GOP 2024 election wins. A meeting with the representative of Chair Weiser occurred at the MIGOP building owned by the above referenced trust, in case it hasn't sunk in yet, to expedite transferring MIGOP resources to the new administration. It's been 21 days since we legally became MIGOP chair and co-chair, and the following items have yet to be turned over to the new MIGOP administration by previous MIGOP chair Weiser administration. I know this is insanely ungrammatical, but that's what she sent out to all the precinct delegates. Patty P says, what fundraising dollars? Good question. No, some of this involves a simple emailing of usernames, passwords, or files, or the like. House file contact lists, donation records and documentation and related resources, Aristotle access, necessary reporting access. By the way, that's not Aristotle. Aristotle is the voter file vendor. They're not, Mertz, I think is what you're talking about, your necessary reporting software.
You have to pay for it. But Aristotle does have a compliance component to it, though. It does.
They do? Okay.
Yes.
All right.
And so, but that's a fee as well, and it's expensive. And the same thing with data. Like they kept saying, like they won't get, because you guys got to remember, I was like inside, like with these people, so they were calling me to like see like what I knew and what I could help them with, and they kept saying that all the data is in a trust. It's in the data trust held by the ex chairs. Well, no. Hey, Adam, what's data trust? It's a company. It's the RNC company that partners with WinRed. Yeah. So they were so confused saying that they didn't give us the data. It's leased. It's rented data. She has to sign the lease for the data. I told her
Yep.
that. She continued to lie, and to this day still says they didn't give us any of the data. Well, the data's rented, lady. Like, I told you that. She knew that back in March.
Yep. Lance Lashaway on Facebook says, "Oh, no popcorn gifts allowed." Hey, maybe one day we'll be multi-streaming on Twitch as well. I don't know that Twitch has a very big user base, but if you guys like those emotes, maybe we'll start streaming on Twitch someday. On YouTube, Left of Center MI says, "What is compelling any of these lawyers or affiliates to associate with Kristina? Kookery. Is your inner circle somehow profiting here? Not for long."
Well,
what do you
let's
think,
let's
Matt?
back up for a second. Right. Let's back up for a second.
Yeah.
Who filed this lawsuit? Dan Hartman did. Dan Hartman did. Now, we talked earlier, I think when this was filed, and said Dan Hartman is a fact witness and it cannot be the attorney. What you notice is they didn't get an actual third-party attorney to do this because they don't have one. The two people who I have sent out thousands of emails since I've been an attorney. I have never put comma JD after my name because that is a degree and not a designation, right? The designation attorneys often use like ESQ, right? Esquire, which I do all the time. So they don't have another attorney. The person that they have is Jim Koppas. Jim Koppas never passed the bar. Jim Koppas is dangling very, very close to the unauthorized practice of law if he has not gone over. The other dude is this guy, Robert Owens, who was made director of communications and maybe fired, maybe not, sending out all these ridiculous emails. He's also, he is a disbarred attorney. He was an attorney and was disbarred after stealing reportedly, allegedly, hundreds of thousands of dollars. It was found by court. He was convicted and his law license was taken away. They don't have another lawyer on staff. And if they go to a third-party lawyer, like one of these firms, they're going to get one of two answers. A, we wouldn't file a suit like this. And B, we're conflicted out because we represent the other side. So you don't do that. So the answer to your question of what's compelling any of these lawyers to associate with Kristina, there's only one. And oh, by the way, he announced he wasn't getting paid. He was doing this out of the goodness of his heart, which nobody believes. What about the other guys? There's no other place for them to go. They're not actually attorneys.
Yep. Lance Lashaway on Facebook says, "Hard to condemn DiPerno for the actions of others. Spinning your reach is a good idea." I assume this is in reference to he's disagreed with my comments about Matt DiPerno. Topic for another night. A little bit off topic, and I've talked about that on streams back in the day when he was running for state chair. But not a topic for tonight. If you like Matt DiPerno, great. I don't happen to agree. That's all there is to that for now. John Smith says she at one time they were considering suing Castilia for data too. They apparently love suing people for things they don't own, so no surprise there.
No, they came to every county chair and said
and asked for their list. They demanded their data.
Their data. We want you to give us your data so that we can create a database from your data.
Yeah, amazing.
And frankly, her whole plan, which she laid out, she said we're doing two things. We're doing election integrity, which she sucks at. That's a time for another. That's a whole other thing. And then there's this thing called the Good Neighbor Program, which is telling the precinct delegates to start knocking door to door to do what? Collect data to give to her. That's not a plan. That's just something else. But Adam, you want to scroll back to the top of that email that you got right there?
This one?
Because it's got an editorial comment.
Yeah.
You see what Jason
JFC.
wrote?
Yeah.
Jesus.
Yeah.
I mean, you read it, it's right there. You saying the exact opposite. And then you've got the Judeo-Christian morality,
I thought about go through this entire email just because it's so ridiculous. And looking back on this after a year about how insane all this stuff is, but it's also very long and I don't want to, but well, I'll just read this sentence. "We are rebuilding a party devastated by decades of an ineffective status quo whereby Judeo-Christian morality and the Constitution are relative concepts, and a party simply ruining Michigan slower than Democrats became the norm." I mean, folks, I've criticized many and plenty of times past Republican state party administrations. That is, even by my standards, incendiary.
Yeah. But you have to understand where that comes from, Adam, right? All these new people that came in, they were all funneled into groups that were told the first thing we have to do is fight ourselves, right? And then once we win that, then we can fight Democrats. These people were never here to campaign to win elections. They were always here as a takeover. And looking back on it now, I see it. And to be honest with you, it's hard when you're on the other side. You don't see it now, but when you read stuff like this and you look at the language and what was going on, these people have been Pavlov dog. They've all been classically conditioned to hate themselves, to hate Republicans. That's what they've done.
Well, they were all told, they all had the same thought in their mind, because this had occurred in Wayne County years earlier. And the thought was, all we have to do is take over the party, and we open the magical mystery box, and it's got millions of dollars and all kinds of things, and then we can get the candidates we like and get them all elected. And when a previous chair that I had worked with took over, the guy who he supplanted, basically handed over a shoebox, and they had just come off an election cycle, and he had spent all the money, because that's what political parties do. And the question was, where's all the money? And the answer is, it's your job to raise it. He spent it, and now it's your job to raise it. That's what you signed up to do.
That's the thing Kristina constantly comes back to all the time is, how dare Ron Weiser leave our party in debt? It's like they always end a cycle in debt. That's how that goes. So that's what that line of credit was for.
Because if you have money left over, you didn't do your job. You didn't go, to the 110% to get those last votes over the line, right? That's the whole purpose, is to raise to be bankrupt on election day. You shouldn't have a dollar in your coffers on November 4th or 6th or 8th or whatever that first Tuesday is.
It's having a bullet in the gun at the end of the war.
Correct.
You wasted it. Now, what's interesting is that when this concept was, by the way, brought from Ron Weiser to everybody who was running for state chair. Remember, there was a guy running for state chair who said, I'm going to do this without money. And then everyone liked that, because they like being told they don't have to pay anything. And then he met with Ron Weiser, as they all did. And they said, hey, look, this is how much money you're going to need to raise just to operate the party. And then there's how much you needed for these candidates and these candidates. And this particular person then turned around and said, well, the way I calculated, every precinct delegate needs to pay $385. And summarily, he's a good dude, summarily lost any support he had, because guess what? It wasn't there. What did Kristina say? I'm going to raise $50 million.
Yeah.
I'm going to raise $50 million. Did you raise?
I want to read a few comments and then move on and call it a stream. Because on Rumble, Meet Me in One just said, you need to give her a chance because she's fighting the rhinos that want control of the party. She's had all year, Meat Man. And I understand there's institutional opposition to her. That's natural. That's understandable. But she's doing these things all by herself. The rhino establishment didn't force her to file this frivolous lawsuit. The rhino establishment didn't force her to write this ridiculous incendiary email. Lance Lashaway says, I've not talked to a single person who believes in a magical mystery box. There was that whole $50 million promise. I'm going to raise $50 million. Lance also says, you didn't leave your job if you leave something in debt. Actually, with the state party chair, yes, you do. Your job is to spend all the money, leave it on the field, because your job is to get candidates elected. And that means spending every dime you've got. Absolutely is. And the assumption is the next state party chair can raise that money, because that's what they were hired to do.
Correct. Quick, the whole job is fundraising.
Yeah. Left of Center asks what my thoughts are on the upcoming DiPerno trial. Don't have time to get into it. I don't know the facts well enough to know. All I'll just say is I don't think DiPerno is a very good lawyer, and I'll leave it there. Let's move on and call it a stream, guys. There's more of this email, and let's just skip past it. Another email. This is, let's see, from Joel Studebaker to Eric Doster. That's the chief of staff of the Michigan Republican Party as of Friday, May 5th, 2023, 12:11 p.m. CC, Kristina Karamo, Daniel Hartman, building-related invoices. Hi, Eric. The attached invoices for the building need to be transferred to the trust and paid/managed through the trust. Because they're your bills, not ours, right? Just let me know if there's any questions or concern. Thanks, Joel Studebaker, Chief of Staff. Jay Michaud asks if a state committee member had resigned before that contempt order came out. Would he or she? I think the issue is, yeah, because it's before the act, not before the breach, or not before the decision.
Correct.
Or the suit is filed.
Yeah.
Yep. It's too late.
Now I've got some bills here. Lansing Bureau of Water and Light. Dear MI Republican Party, this is a reminder that $2,300 $370.83 is past due on this account. If payment has already been made, please disregard this bill. And here's your bill. And here's another bill for $327, which looks like probably a monthly rate right there. That's on, or it's probably how much they pay in utilities. Here's see, here we go. Here's another bill with a overdue amount. You've not paid your $2,600 in the past. Oh, well, actually this one, I don't know. I know what period this is, but who cares? Anyway, it's electric bill. Good amount of money. Not $12,000 though, but there it is. More electric bills. More electric bills. Here's Luke Landscaping Company with a bill here for, let's see, looks like snow shoveling, snow salting.
I got to get that contract.
Snow shoveling. And this must have happened a number of times throughout the year, and it was a little under $800. Please send payment past due. State of Michigan. Oh, this is the order. This is the they included as an exhibit the sanctions order against Kristina, whose attorney at the time, of course, was Dan Hartman. And defendant Janice Winfrey, in her official capacity as Detroit City Clerk, brings a motion for attorney fees and costs claiming plaintiffs complained from mandamus, preliminary injunction, declaratory judgment, other relief was frivolous under Michigan law, and the request for attorneys fees and costs.
That was $58,000, correct?
$58,459.20.
Yeah, so the thing about that is that press conference for the woman who came forward in that, which actually took place at my office back before the election. And there was this elderly African-American woman that they cherry-picked out of Detroit, and she's named in this too, and she didn't have two pennies to rub together, right? So Phil O'Halloran, Alexria Taylor, Kristina Karamo, Dan Hartman, and this elderly woman. They put this poor elderly woman in sanctions, and they still haven't paid it. They're fighting it. But like, this is what I'm saying. It's like elder abuse. There was a situation that happened in Royal Oak just a couple of weeks ago with the 82-year-old vet that paid the $6,000 for the canvassing thing that the canvassers threw him out at. Like, this is disgusting what they're doing.
Yeah. And Jay Michaud says, wait, the same Alexandria Taylor running for Senate, the same one at the debate that Kristina did not recuse herself from the other day. Yeah, she was the attorney for Kristina Karamo. And Daniel Hartman. By the way, I'm getting feedback on someone's. It must be yours, Matt. I don't know if you did something about that, but I'm suddenly getting feedback in my headphones. It's not too bad. I can probably power through it. But here we go. Let's just finish this off. Sanctions. Well, you get the idea. Frivolous, prevailing party. Request order. Blah 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 blah. This court finds plaintiff's complaint and motion for disqualification of the entire 57-judge Third Circuit bench to be frivolous under the Michigan court rule. The complaint was for disqualification of the entire 57-judge Third Circuit bench. Yeah, Jay's getting feedback really bad. Matt, are you muted? Can you mute yourself and see if that does anything about it? Matt, can you mute yourself, please? Hello?
All good now.
Okay, it's better now? Good. Okay. No, it's not. Now it's back. Matt, mute yourself, please.
Yeah, that's me.
Okay. This court finds plaintiff's complaint and motion for disqualification of the entire 57-judge Third Circuit Court bench to be frivolous under the Michigan Court Rules and MCL 600.2591. Sanctions are to be imposed jointly and severally against the attorneys David Hartman, I think they mean Dan Hartman, Alexandria Taylor, and all the named plaintiffs in the October 26, 2022 complaint. This court has reviewed the proposed attorney fee request, including the documentation of time expended, the hourly fee sought. The hourly fees are reasonable, consistent with the expertise in election and municipal government law, and with the Oakland County rates for their similar legal work as guided by the State of Michigan 2020 Economics of Law Practice, Attorney Income and Billing Rate Summary Report. This court will exclude $4,893 in attorney fees sought for services submitted for the sanctions motion as not reasonable, and for the motion in brief, all other costs and attorney fees are reasonable. Defendant Janice Winfrey, in her official capacity as Detroit City Clerk, is awarded costs and attorney fees in the amount of $58,459.20, June 12th of this year, which means, that's right, folks, Kristina Karamo and her attorneys, including Alexandria Taylor and Dan Hartman, owe the Detroit City Clerk for their lawsuits. Yep. Good job, guys. The end.
Yeah, they're gonna get a threesome here, right? Three sanctions in 1 year.
Yeah, the end. That is the reply. That's from the State Party Trust. Next up is Comerica, folks. And that one might take two
Oof.
streams to go through. But
Yeah, that's going to be gnarly. I feel bad for people on state committee right now.
I do too. And at least if 107 of them get together after this is all over and see the pants off of Kristina Karamo, they might be able to split those legal fees 107 ways. But then again, she can't pay. So what is that going to do him? Very fucked up.
Somebody's paying this woman, because if she's not accepting a salary, someone's paying this woman.
Yeah. Meatman says, if you're so worried about fundraising, why don't you help her and stop complaining? Why is that my job? She wouldn't have ran for that job.
I would
Promising to raise $50
I wouldn't
million.
give her a dime. She'd give 10 grand to James O'Keefe for not showing up to Mackinac if I gave her any money.
Yeah, no kidding. Todd Gilman says liability. Yeah, that's a topic for another night. Another night, Todd. We'll talk more about liability.
He's on deck. Don't worry.
Yeah. Last comment. Lance says that the magical mystery box existed. Why would the party be in debt? Because it doesn't exist. They thought it existed. Why'd it be so important for KK to raise $50 million? Because that's what she promised to get herself elected. She said, I will raise $50 million. I'm going to flip the whole party fundraising paradigm on its head and bring this whole army of small dollar donors from all the businesses in Michigan, and they're going to raise $50 million to elect Republicans. And none of that materialized for some strange reason.
I know exactly why it didn't materialize, because the woman she had running it was going through a divorce or had a health issue, and Kristina never reached out to her, and then that woman just went away. It never had any follow-up. It never had any legs. It was just a lie on the campaign trail, just like the $50 million was a lie on the campaign trail.
Yep. All right, final comment, because I like this one from Rumble. Amy F. says that Kristina Karamo supporters behave exactly like the President Gay supporters. They don't care that she's surrounded by clowns. Yes, they will make every excuse for her because they're emotionally invested in her and because it suits their agenda to defend her, despite the fact that it's indefendable.
It's personality over principles.
There you go, folks. Matt, Warren, thank you, gentlemen, for joining me tonight. We will certainly have another stream on Sunday for our regular weekly rundown. And who knows, if we get that Comerica suit sooner, we might even have one sooner than that. But as soon as we do, we're going to start. Not the suit, I'm sure it'll be a motion.
Response.
Maybe not an answer.
Yep.
So we will go over that when the time comes. And I'll probably see you gentlemen this Saturday at the state committee meeting.
Thanks so much, you guys. It's great to see you.
See you.
All right. Good night. Oh, hey, folks, by the way, if anybody has been able to TiVo that Let It Rip segment with Kristina, send me a link, would you? I'd love to see it. All right. Good night, guys. See you next time. Peace.